Hi guys, welcome to Learn Kenyan Law with Wanjiku. Today we're having commercial law and we're basically going to talk about the historical development of commercial law. We're also going to be able to understand how was commercial law incorporated in common law, and finally we're also going to talk about how it was finally incorporated in the Kenyan society as we know it of now. So the modern commercial law has its roots in the Lex Mercatoria of the Middle Ages. The Lex Mercatoria literally means the merchant law, and the merchant law evolved as a system of custom and practice, and it was enforced through a system of merchant courts along the main trade routes. The Lex Mercatoria also functioned as the international law of commerce. It was also applied to cross-border disputes by the market tribunals of the various European trade centers. It is also very important for us to note that the Lex Mercatoria comprised of a relatively comprehensive, efficient legal regime for trade beyond local borders. Another important thing that I would like to mention when it comes to the Lex Mercatoria is that it was for the merchants, it was created by the merchants, and it was adjudicated by the merchants. So basically the legal system of the Lex Mercatoria was operated by the traders and their agents. The most important function was very straightforward. Lex Mercatoria enabled merchants to escape conflicts between various local customs and rules and to avoid submitting to the authority of judges attached to pre-existing jurisdiction. So what do I mean here? What I mean here is that the Lex Mercatoria, as I have mentioned, was for the merchant. It was created for the merchants, and it was only supposed to adjudicate matters concerning, merchants' disputes. So the function was that they were trying to avoid submitting to the authority of the judges of their other pre-existing jurisdictions. So by the close of 12th century, the Lex Mercatoria governed virtually all long-distance trade in Europe and through middlemen and their codes of conduct at critical points along the great Mediterranean and Eastern trading routes. Lex Mercatoria again was voluntarily produced. This is to say that the law was voluntarily made by the merchants. It was voluntarily adjudicated. This is to say, of course, there was no coercion, and it was voluntarily enforced. And it had some constitutive principles which made it a success. One of it was good faith. When I say good faith, I mean promises must be kept. And this was a very important principle that the regime of the Lex Mercatoria had. There was also the principle of reciprocity, non-discrimination between foreigners and locals, and of course third-party dispute settlement and conflict resolutions, which were favoring equity settlements. In practice, Lex Mercatoria required traders to use contracts. Okay, even right now, we're still using contracts when we're doing business transactions. And even then, it was a requirement that they use contracts, and it was gradually standardized. And of course, when you're using contracts, it was easier for them to settle disputes in courts. And as I have said, these courts were staffed with other merchants. Another important thing to note is that when it comes to the Lex Mercatoria, the merchant judges placed a premium on quick judgments, and they de-emphasized the adversarial procedure. For us who are in the legal fraternity, of course, when you talk about the adversarial procedure, we generally just mean how the courts carry out their the procedure that you have to follow when you're filing a case in court. And of course, sometimes the procedure is too long and the procedure is too technical, and sometimes the procedure takes a whole lot of amount of time and you're almost about to give up on the case. But when it comes to the Lex Mercatoria, the merchant judges placed a premium on having quick judgment so that they were able to conduct their business. So the function of the dispute resolution was not to declare who is a winner and who is a loser, but rather to resuscitate the contractual agreement, and so that to enable the parties to get on with their businesses, of course using norms of fairness between the parties. And then I know one might ask, what was the effectiveness of the Lex Mercatoria? It is important to note that the effectiveness of Lex Mercatoria depended critically on the reputation effect and the fear of being ostracized from the trading community. Of course, if you're a business person, your reputation is key in the business fraternity. And of course, no one wants to be ostracized from the merchant community. So what made the Lex Mercatoria effective is that the threat of being ostracized from the merchant community and your goods being boycotted by buyers, it proved more effective than the normal state coercion that was taking place at that time. So those who lost their reputation also lost their trading partners, and of course they also lost their access to the Lex Mercatoria. The advantages of having the merchants themselves develop the law of merchants is that the law of the sale of goods developed in line with the needs of the market. So this is to say, this law was specifically, again I have said before, this law was specifically designed by the merchant. And once you are the one designing the law that is about to control you, of course you're going to develop the law that is in line with what the markets need, what the market needs as the buyer, and what the market needs as the seller. So it's really important for us to note that the Lex Mercatoria was not a coerced law. So let's continue and talk about what was the need of the rule of law of merchant. Of course, the most important need of this law was that it was only meant to facilitate interactions between players in the market. It is also very important for us to note that the Lex Mercatoria was not complex. And of course, I have said this, it was not enforced in a coercive manner. We've talked about how it was enforced, and it was purely enforced by threats of being ostracized by the merchant community. It is also important for us to note that, as I have said before, the judges who were in the law of merchant, they were selected from among the merchants. This means that the judges themselves were businessmen themselves. So let's juxtapose it with common law judges. Of course, the common law judges were just purely educated in law, but they did not have a practical experience on, on what the merchant fraternity is. It's very different from when the businessman is the lawyer, from when a lawyer is a lawyer but has no practical experience in the industry. So, of course, the common law judges would follow a very strict codified rule, whereas the merchant judge would prefer simplicity and continuity of the business. Now, let's talk about the incorporation of the Lex Mercatoria into the common law. So, around the 12th century, governments across Europe started codifying the rules of the law of merchants. And for example, like England codified the Carta Mercatoria, which literally means the Charter of Merchants. And what this charter did, it guaranteed the merchants freedom of trade, exemption from additional taxes and duties, and protection under the law. In England, again, the government enacted the Statute of Staples. And generally, the Statute of Staples was to protect the merchants in the 14 major trading centers for the staples products that included wool, leather, and lead. Of course, through the Statute of the Staples, the merchants were able to appeal to the royal courts and the King's Council if they were dissatisfied with the decisions of the merchants' court. So what am I saying here? When England came up with the Statute of the Staples, the merchants were now able to appeal. That is to say, when they went to the Lex Mercatoria courts and a ruling was given, in case they felt like they did not agree with it, they had the ability to appeal in the royal courts and the King's Council. And this is how the government was able to weaken the law of merchant courts. Then again, it's also important to note that the government also started controlling foreign trade flows, such that any goods that were coming out of England, they had to pass through identified towns, and of course, special courts were established to adjudicate upon disputes arising from such trade. Again, I want us to talk about the interest of the judges in terms of the common law judges and in terms of the merchant judge. With the common law judge, the main aim, or rather the interest of a common law judge, was to protect the financial interest of the state. Of course, they would do this because they're employed by the state and they're paid by the state. So their most important interest would be to protect the financial interest of the state in the commercial environment, whereas a law merchant judge would only protect the interest of the merchants. As I had said earlier, the merchant judge was a merchant himself. So his interest would be to protect the merchants. So of course, through all this, the state gradually succeeded in moving sale of goods disputes to common law courts by the 16th century. So we continue, and we're also going to see that we have legal historians who have credited Sir John Holt and Lord Mansfield as the founders of commercial law in England. This is because they were able to help in the codification of the law of merchants, which existed even before their time. Of course, after being incorporated into common law, a need arose to codify commercial law. Certain areas of commercial law were therefore codified in statutes. Of course, commercial law is so wide. There are some certain areas that were therefore codified into statutes. Some of them include the Bills of Exchange Act of 1882, We have the Sale of Goods Act of 1893 and the Marine Insurance Act of 1906, among others. So now in Kenya, of course, we have several laws governing these transactions, most of which we copy-pasted from the English laws. Some of them are the Sale of Goods Act, Cap 31, the Law of Contract Act, we have the Hire Purchase Act, Cap 543, and the Chattel Transfer Act, among others. So let's continue and ask ourselves, how was the transplanting of the English Sale of Goods Act in Kenya? What was the process? So the English Act was adopted almost verbatim by the Legislative Council of Kenya Colony in 1930. Of course, we were colonized by the British. So the Legislative Council of Kenya during 1930, they adopted the English Act verbatimly, and it was first enacted as the Sale of Goods Ordinance, and it commenced on October 1st, 1931. And so this specific act was imposed on a society that conducted its business largely on barter trade terms. So can you imagine, we were just here conducting our businesses on barter trade terms, and then we were imposed to have this Sale of Goods Act. From a personal opinion, I don't feel like we really needed it at that time. But as we know, this act was passed at a time where the white man was trying to create, a white man's foreign country in Kenya. Because if you even look at the history, the Legislative Council that passed this act was an all-white, meaning we did not even have an African representation when this bill was being passed. And so the Attorney General at that time moved the bill in July 1930, and of course there was no debate as the bill was unopposed. No one was there to oppose the bill. Remember, I've said that it was an all-white people who are there who really passed the bill. We did not even have an African who represented us. And take note, this bill was being passed in 1930 when us in Mombasa, in the coastal region, people used to use cowrie shells as the medium of exchange. You know, when you go to the Bantu societies, they used to exchange animals. You know, you get a goat, you give 10 goats for 1 cow, such things. And so this act was really enacted, was really adopted in Kenya really early. And as we can see from history, it was adopted because the people who are colonizing us, they actually were the one passing their bills at their home country. And so that is how we got to have the Sale of Goods Act here in Kenya. So thank you so much for joining me. And of course, having understood the historical development of commercial law, it's easier for us to now understand how we ended up having this law in Kenya. It is also very important for us to note we're still using the same acts. The same act that was passed by an all-white man is still the same act that we still have now. And so, of course, we're going to still continue with that discussion, but that is what is governing us. I hope to see you in the next lesson, of course, and feel free to reach out. Feel free to subscribe. In case you have any questions or any requests, feel free to write them on the comments below or use the email address that has been provided. Thank you so much, guys. See you next time. Bye.